For those of you who don't know me, I'm Ben. I'm Chief Commercial Officer at Penta Hotels and form part of the HEDNA Board of Directors. Greg, welcome.
Thank you. Thank you. Welcome to all of you in our beautiful city. I'm from Seattle, and as I shared with Sebastian, my office is 2 blocks away, so it was a short commute to this year's conference. So,
perfect. So we're going to talk a little bit about the legislation changes that have happened, and I guess in the last 2 or 3 years, most people have been preoccupied with other things that have been going on in the world. So there's probably quite a few changes that have happened that maybe have got under the radar. If we go back to 2021, the Pennsylvania and Marriott case, particularly around resort fees and things that were happening there and where it was deemed to be perhaps unfair for hospitality companies. Talk to us about what you think that means for the industry, and do you think that's something that will continue to happen? I saw Airbnb last year announce that they would now move to kind of transparent pricing where everything would be in at the top of the sales funnel, so you would see. Do you think that will follow through with all companies?
The short answer, I think, is yes. I think it will take some time. Obviously, the hoteliers in the room will know that you've been under a lot of scrutiny in terms of total pricing and hotel fees and resort fees and other things. The result of that, obviously, was many state attorney generals raising issues, and actually in Pennsylvania's case, actually filing a claim against Marriott in particular. What I'm looking at more is those state efforts are piecemeal, and a lot what we're going to talk about today, unfortunately, there are piecemeal efforts, which makes compliance difficult. But what I'm particularly interested in is at the federal level, and as many of you probably know, the Department of Transportation has already issued a proposed rule on the airline industry, and particularly their fees. But more importantly, the Biden administration has declared war, if you will, on surprise fees as part of their inflation or combating inflation efforts.
Called them junk fees, right? That was the
yes.
statement, junk fees.
Junk fees, so-called
Yep.
junk fees. And late last year, the Federal Trade Commission issued a notice that it intends to make a rule. So it has not yet issued the rule, so we don't quite know what that rule might be, but they intend to issue a rule, and they're now currently collecting comments, which I understand have been plentiful. If the FTC proposes a rule, there will be more opportunity for comment. But if that then becomes the rule, then everyone, not just Marriott, will be subject to this requirement. The interesting question will be, and this came up in the AG case as well, is will the rule apply only to the suppliers themselves, hoteliers, airlines, what have you, or will the third-party distribution platforms also be subject to these rules? And if you look at the Department of Transportation's rule in the airline industry, it is very clear that it applies to anyone who is distributing that inventory. So if the FTC follows a similar path, you should expect that the FTC rule will apply uniformly to anyone who might be distributing a hotel rate.
Okay. And so in regards to those, how would it be passed in terms of, essentially there is a fee for a service, right? Whether we believe that the resort fee, for example, is extortion or not. In some cases it is, right? Some cases it's clear profiteering. Other cases, perhaps it's you're paying for a service. So how can a law be passed that would then, essentially, you're not hiding something if you're giving a service, right? If you're saying that you have to show what that service fee would be. So is it any different from Wi-Fi being charged in the hotel, for example?
It's a bit different than Wi-Fi because these fees are mandatory, right?
Yep.
In theory, you don't have a right to reject them. What the FTC is most concerned about is disclosure. Mm-hmm. So while these rules may be couched in terms of going after these surprise fees or junk fees, what they're really focused on is just ensuring that there's disclosure. And at the end of the day, total price, what's included in total price, it must be displayed front and center. That, I think, it's hard to argue that that's a good thing, mm-hmm. provided that there's parity in the industry, that everyone must do the same thing. I think they're just most concerned about just disclosing it. They're not, despite the president's comments, they're not attacking the notion of having these additional fees. It's more of a disclosure issue.
Okay. So you wouldn't see it being a challenge so the industry, we spoke yesterday about attribute-based pricing, and I think it's been talked about for 10 years or so now,
yes.
and we're still, hopefully one day we'll move in that direction. You wouldn't see any restriction on that particular type of pricing or selling if you're saying that it's only if it's a mandatory charge that's being added. So would properties still be able to price individually for services that they would need to?
Yes, if they're considered optional services,
Okay.
and if it's clearly disclosed that in exchange for this fee, you'll be receiving this amenity or attribute or facility access or whatever it may be, I don't see there being a problem with that. It will be an exercise in disclosure, but I don't see it prohibiting it.
Okay. And for the hoteliers in the room, would you recommend that they start to look at this now in terms of a pricing, or
That's the
wait for
million-dollar
guidance?
question.
Yeah.
I get that question often. I think there's two schools of thought. There's one that if Marriott is going to do it, and they're in the process, as I understand, of preparing their systems to do it effectively. And in Pennsylvania, they gave them a timeline to do that. Mm-hmm. So there's one school of thought that if Marriott is going to do it, then we should fall in line and everyone should do it. There's another school of thought that says, particularly for smaller hoteliers, that say, I'm small, the likelihood that I'm ever going to come under scrutiny, either from the FTC or the state AG's office, and you pick your state, is so low that I'm never going to get asked a question. I'm just going to put it off and never deal with it. Yeah. Many of our larger clients, and we tend to represent suppliers in this equation, many of our larger clients are putting this in their technology paths for future development, only because, as I understand it, and I'm not a tech person, I understand that the lead time to implementing total price effectively can take some time.
Okay. Another topic that I guess is being relevant in cookieless world, and again, 2023 was the plan, it's now 24 for Google, and we'll see whether that happens there. The topic of guest privacy in general, how do you see that kind of developing? Do you think something will happen in 23/24, or do you think we're further away from this cookieless world and guest privacy?
So two questions there. Right. Cookieless world, are we going to get there? I think yes. Mm-hmm. And I think that motivation is both a commercial motivation in terms of planting a stake in the ground and saying we take privacy seriously. So there's a marketing commercial component, and then there's also a legal compliance component. Legally, as we all know, GDPR, our favorite acronym out there, that will continue to evolve. You know, we've seen changes in China last year. We continue to see changes in the US as each state, here's my word again, piecemeal, in a piecemeal fashion take on privacy. This will forever, sorry to disappoint everyone, this will forever be an issue. Yeah. And I know from our contracting work and the work that we do, you know, the discussion around privacy has almost become easier. When GDPR first took effect, there was a lot of discussion about, well, what does it mean and how does it apply to me and what do these rules really mean? I like to say that most of the transactions that we're part of today, people have a pretty good understanding today of what GDPR requires. And inevitably, with every deal you do, you're going to have your data privacy provisions or your addenda or whatever it is, and attached to that are the standard contractual clauses. It's become easier to deal with, I think, commercially today. Mm-hmm. It's just the challenge of keeping up with the changes. That's become the challenge.
Yeah. And so you think the kind of changes in Web3, blockchain, et cetera, will they be accelerated because of GDPR, because of data privacy? Do you think that's at the root cause of what people are more interested in?
I think if it solves data privacy concerns, yes. Otherwise, I wouldn't view privacy as a motivating factor as much. Okay.
And so for the years ahead in data privacy, are there any other changes that you foresee happening, things that are being spoken about currently that would see any material changes to perhaps the way hotels operate, or separate booking channels would have to change in what they do?
I guess the fundamental sort of point I would add there is, for years there have been arguments, whether it be in the hotel management world, the franchise world, marketing world, whatever it may be, there's been this argument about who owns the customer, right? I'm sure we're all familiar with that, those of us that have been in the industry at any period of time. Who owns the customer? It's pretty clear if you look at GDPR and other European privacy regulations, it's very clear that the person, the individual, owns his or her information. Mm-hmm. And so what effect that has on this ongoing debate about who owns the customer and his or her information, I think someday that might start to affect that, where you don't have everyone clamoring for claiming ownership of that guest. and then imposing their rules around that guest. I think it's going to get easier as we become more comfortable with the idea that the traveler owns his or her information. We're all privy and have the opportunity to use that information, but at the end of the day, it's owned by the individual.
Yeah, okay. One of the major topics, I guess, I think it happened just before Christmas, was the rise of ChatGPT, right? And we spoke about it yesterday. But going further into that, there's all forms now of AI around content. So, for example, I can type into a search engine, show me an image of a hotel room in Las Vegas from the 1970s, for example, and it will create this image. Who owns the content now? So with these forms of AI and particularly ChatGPT, and there was a really interesting comment I read yesterday. Well, when will it take for the first book to be written by an AI using data from elsewhere? So from a hospitality point of view, who will own that content and who's responsible for the upkeep of it?
Well, now you're pushing the boundaries of my knowledge, for sure. And I'm not sure you would find many lawyers that would be willing to opine on or give you a definitive answer there. If we rewind a few years, there was this fallacy that we often ran into, which is, if it's online, then I can use it. And I don't know how many times we ran into issues where our hotel clients, for example, would post either written content, narrative, photos, video, or what have you, only to learn later that the copyright was held by someone else. Okay. So there are, or there should be, at least strategies in place today that if you're using those types of materials, and whether it be a written narrative, photo, what have you, there should be a policy or practice in place to ascertain where did this come from and who might have created it, and has that individual given me the rights to use it in the way that I choose. Now, there are obviously databases and other things out there where this content is free, but generally speaking, whenever I'm working with someone who's creating content, that is front and center about what is my ownership rights, what are my license rights, what can I do or not do with that, can I post it here or post it there. When you talk about AI-generated content, and this is just one person's opinion, I think it's going to go back to the same fundamental rule, is that who, in this case, may have created the technology that then created the content, and is that the trail of ownership, or is it the person who licensed that AI content that then the person who licensed the AI platform to create the content, do they own it? I think you need to stick with fundamentals and try to go back to the fact of where did this originate? Yeah. And who owned the technology that created that content? That's where I would start.
Okay. It's interesting because the image generation, I don't know if any of the audience have looked at some of the image generation that you can get, but essentially the systems will layer different types of images on top of each other. So you take one core image and then it's merged with 3, 4, 5, 6 other images within there. So you might find a component, your base image may be of a hotel room here at the Fairmont, but actually the bed may be from the Marriott across the road, or the curtains or the drapes may be from a different property. So I think that's the interesting part from a legality point of view. All of these kind of different layers of images and content, who will own those and who is responsible for those? But so you're saying really it's the operator of the AI function would be the first place?
That's where I would start. That would be my default. It's interesting, your layering issue, because arguably every person that contributed to that combined work would have a claim at least to the component that they contributed. So my suspicion is that there will soon be ways in which commercially this is worked out and that there are terms to address this. But for now, I think it's almost anyone's guess. If you are using content created that way, it's going to be a challenge.
Okay. Moving into a totally different direction. Okay. I realize I'm putting you on the spot in lots of different ways, but taxation. You mentioned earlier there'd been kind of a piecemeal approach across the US in terms of how different states are applying different things. A number of changes in taxation between online marketplaces by state, etc. Any changes or updates that you have been particularly top of mind at the moment that you see?
Well, once again, piecemeal that's our term of the day, little did I know. I say twofold. One is we're seeing changes internationally, and disclaimer here, I am by no means an international tax lawyer, but we're seeing changes internationally that deal with distribution in a broad sense of it. Changes in Mexico, for example, have driven a lot of contractual changes with many of the distribution platforms. What I find interesting is that, particularly in the U.S., thanks to our friends at Amazon up the street, there is now a renewed focus, if you will, on states by lost revenue associated with online transactions. And all of you that have been in distribution for any period of time are very familiar with the years of litigation between net rate merchant model distributors and local and state tax authorities about taxing on the retail rate versus net rate. We've all been there and seen that. In response to that, and in response to a Supreme Court decision in the US several years ago, many states now have these marketplace facilitator statutes and regulations, which essentially says if you're going to come and do business online in our state, and you are a facilitator of transactions occurring in my state, you, the facilitator, need to impose and collect and remit the tax, not, in our cases, the hoteliers. The problem with that is piecemeal. It's been done on an individual state basis.
Yeah.
There is some uniformity. If I laid out for you all of the state's regulations and asked you to compare them, many of them have many of the same thresholds and ideas, but how they apply to a particular distributor or a particular supplier, it really ranges. And so it's interesting from my perspective, looking at contractual provisions around taxing authorities. There are many distribution platforms that I've talked to in the last, I'd say, 6 to 9 months, that they admit they don't understand the US tax requirements, and in many times, even though the legal obligation might be theirs, they're looking to their hotel supplier partners to actually still do that because they don't understand it.
Yeah.
And so that's evolving. States that haven't passed those yet, inevitably they will, because it's an opportunity for more revenue.
Yeah.
And so it's not too far away where I would say every state in the US will have its own variety of these marketplace facilitator statutes.
Oh, wow. Okay.
So lots of fun for tax collections.
You talked about international and changes that have happened, and it's something that may have escaped some of the US audience, but the cases in the EU, the DMA Act, the Digital Marketing Act, essentially, has the potential to completely change everything about our industry from an online search engine perspective. And we had a talk on, I think it was, what day are we today? Thursday, no, Wednesday, Monday, on the first day, about 88% of meta search revenue for this particular survey was coming from Google. Now, the way that the DMA Act works, if I understand correctly, would mean that companies such as Google, and it's not just Google, but such as Google, would not be allowed to allow companies to, essentially take funds from those companies to feature higher. Everything would have to be organic in terms of a search requirement. So it would be huge, right, for the industry if that was to follow suit.
Yes.
2024, do you see, I think it was only started to, and just yesterday I was alerted that 8 states in the US have now filed a similar lawsuit against Google for the same practice. Do you think this will ever be allowed to happen?
Short answer, I think, is yes, we will see change.
Yeah.
I'll address your first immediate question, and then we can talk about the broader EU implications in particular. I think there's, 3 or 4 now federal cases pending against the major platforms here in the U.S. brought by federal authorities, and now we see states doing the same. Inevitably, there will be some changes. Will it be better for everyone? Potentially. At least that's the declared motivation of many of these, is that we're trying to break up these organizations that have monopolistic power, if you will, or authority in controlling, in Google's case, digital advertising. Mm-hmm. So will that change the landscape? If the cases are successful, yes. Not unlike many years ago that we saw cases brought against Microsoft. What it means today, though, is what I find interesting. And I don't know if you were going to the EU competition laws on a more broad scale, but of all of the work that we're doing and the changes that we're seeing today, the number one change that we are trying to respond to almost daily are the changes in EU competition laws. And the DMA is a good example. So for those of you sitting here saying, I have a portfolio that's entirely in North America, or I'm in Mexico, or I'm in the Caribbean, or I'm in Asia only, what should I care about, and why do I care what the EU is doing? The reason being is that how those rules apply and to whom they apply is a matter of, I would say, dispute or at least disagreement. Historically, take parity, for example. Many of you are familiar with the wonderful terms of parity. Historically, we looked at the location of the hotel to apply those rules. So if you're in the EU, you have one set of rules, often narrow parity. If you're in the US, it's broad parity based on the hotel location. Many of these changes that are going on, it's not clear whether those same rules of application apply. They're intended to benefit the EU consumer. So one could argue that a rule that's adopted in the EU protects that consumer wherever he or she may travel, which arguably could affect a portfolio of hotels sitting exclusively in the US. So that's the first question. Where it affects the relationship, I'm finding in three different areas. One is rate parity.
Yeah.
We know that there's been an all-out assault, if you will, on parity, particularly in the EU. You're seeing that ebb and flow, if you will, in other countries. India recently had a decision that dealt with rate parity. You see this in Australia and New Zealand and in some Asian countries. The assault on parity continues. To your point about the DMA, if a distribution platform should get caught up in the DMA, and there are rumors out there about certain distribution platforms might be, the DMA outright prohibits any form of parity. So if you have a contract with a particular EU distributor today that has all sorts of parity provisions, in theory, if in fact they are subject to the DMA, all of those provisions go away. And so what that means for yield management on rate and inventory, it'll be a crazy period of time should that happen. But that's just one area. The other two relate to resale price maintenance. So in short, the ability of a supplier partner to dictate minimum price, which is typically what we see in the distribution world. The EU competition rules, particularly some adopted in late last year, make clear that those restrictions or requirements that a supplier might impose to maintain rate parity, those too may now be illegal and unenforceable. So a distributor, in theory, could take the rate that you provide today, they could apply a discount to that rate coming from their commission or their margin or what have you. You would still receive the rate you receive, but they go to market with a much lower rate, which then creates issues for you on your own rate parity side. The third area that we're seeing this is in the area of keywords. And I know you were alluding to that a minute ago. These same regulations that have been adopted this past year, coming from a decision involving the Guess apparel company a few years ago, these rules are also suggesting that prohibitions on the use of trademark terms, whether in the form of keywords or negative keywords, that those too are unenforceable and now illegal. So now you take in your marketing plans where you allow certain uses of your trademarks and prohibit others, at least in the EU, there's a question whether or not prohibitions on keywords, whether those are enforceable. So if you put all those together, and if you're dealing with a distributor that's based in the EU or someone who's trying to protect the EU consumer, your relationship potentially may look a lot different.
Okay. And I know it only was announced yesterday in terms of the 8 states that kind of raised this particular challenge. Do you see more states following suit? Do you think it will become I wouldn't say jump on the bandwagon, but these 8 have done, and I know the rest would also look to do? And what's the benefit for the state in doing so?
Well, there's a political motivation.
Yeah.
I know that because some state attorneys general tend to be a little more aggressive than others, and one would argue it's entirely for political purposes, but I don't know if that's the case or not. Short answer is, will more states do that? I think yes, particularly if they start seeing some success either at the federal level with the FTC type actions, or if other states are gaining concessions that the state and or its citizens might find beneficial. I think you might find more states doing that.
Yeah, okay. And a final question for you. Is there anything that, aside from the topics we've discussed today, that in your work and you're already starting to see more and more frequency behind something, or something that you think that the audience may need to be kind of aware of at the top of mind for future?
Yeah, I guess, and I know so much of this conference has been dedicated to payments. We're spending a lot more time on payments than I ever imagined. in the key buzzword fintech or what have you, and the fact that so many, both supplier side and on the distribution side, are viewing payments as one critical step in the words of one, the connected journey or whatever it may be. We're spending a lot of time on fintech and the effects of fintech. There's a misperception out there among many that fintech is the wild, wild west. It's not regulated. There's no laws that apply to it. We're going to do whatever we want to. That couldn't be further from the truth. And those of you that are in the payments world, you know that. The fact is that you've married a very old, heavily regulated industry in terms of finance, and you've just partnered with a technology company that distributes your products better than you could historically. The finance side of that equation is still bound by the same, sometimes ancient, rules and regulations that limit that. So that's a misperception, and I think some people want to go the fintech route because they view it as easy and we can implement it without concern. That's not necessarily the case. But the broader picture then is if a particular supplier or distributor adopts fintech, which is another word for travel insurance in some instances. If they do that, what are the effect of the other commercial aspects of their relationship? So think about price maintenance or parity or what have you. Is a room that can be bought today and paid later over 4 installments, how do you analyze that rate versus the pay in advance or pre-purchase rate? Is that parity? Yeah. Is that different? If I offer you a more lenient cancellation policy in exchange for a small fee, how do I compare that to the supplier's standard cancellation policy, and is parity being maintained? That's where we're spending more time helping people sort of think through that, and the effect of adopting fintech and these other tools on a traditional distribution model. It's sort of changing or making more difficult some of those questions.
So in regards to buy now, pay later, you referenced there in regards to potential interest that could be charged on there. So if the room rate was $200 and I chose to pay that over 4 installments and I paid an insurance premium, then is that where the parity will create issues? Because maybe I pay $10, $20 in interest payments over that period. Potentially,
and if a critical term of the rate that I've offered you is when it's paid. So example, if I'm offering an advanced purchase rate to you, and you take that advanced purchase and you tell the guest that, no, yes, it's advanced purchase, but you know what, you can pay for it over 4 months. Mm-hmm. Does that change the fundamental nature of the rate that I've given you? And yes, the dollar value may be the same, but the payment term, which is sometimes as critical as that actual dollar amount, that payment term has been turned on its head. And so that's where we're finding a lot of discussion about, particularly with distributors that are looking to do this, as they adopt these payment platforms and payment alternatives, what does that mean for the supplier's efforts to maintain rate parity, and how do we enforce or respond to that? Okay. I mean, a lot of information, which is really super useful, though. Sure, yes. This is always a little treacherous when you say ask the lawyer anything. Yeah, ask the lawyer anything you want. Okay. Oh, no one wants to ask the lawyer any questions. Okay, well, in that case, well, really appreciate everything you shared with us. It's a pleasure being here. Really. Welcome to Seattle. Thank you very much. Thank you. Thank you.